A legal challenge to the European Central Bank launched in a German court last week has huge implications for Brexit, proving the UK will be able to break free of the European Court of Justice (ECJ) once it quits the bloc at the end of the year, a legal expert has said. Barney Reynolds, a leading UK and international financial services lawyer and a partner at Shearman & Sterling LLP, was speaking after plaintiffs including former MEP Hans-Olaf Henkel initiated the case, at Germany's Constitutional Court, based in Karlsruhe. They argued the ECB's use of the Public Sector Purchase Programme (PSPP) in a bid to mitigate the impact of the coronavirus by purchasing private and public sector securities to the tune of £657 billion €750 billion represented direct financing of governments. The court concluded the German government had failed to adequately scrutinise the objectives and mechanisms of the scheme, setting the German legal system on a potential collision course with the ECJ. Mr. Reynolds told Express, "This is relevant to Brexit, since many in the UK establishment have wrongly taken the view that all sovereignty was signed away to the EU during our membership, leaving us solely with the right to leave. More importantly now, a similar view has been taken by some of the binding nature of the withdrawal agreement. The German Constitutional Court has affirmed that certain elements of national sovereignty are not delegable through such arrangements and that those arrangements can be measured against whether they encroach on fundamental national, constitutional concepts. As such, Mr. Reynolds urged the UK to take careful note of the unfolding events resulting from the court decision in Germany. He explained, much of the muddle in the UK context arises from the fact that we have an unwritten constitution. There are huge benefits from our hallowed approach. However, one weakness is the willingness of some to allow rights to be washed away through the lack of their obvious written underpinnings. In Germany, where the constitutional fabric is more clearly mapped out, there are fewer uncertainties and a belief in constitutional sovereignty and the sanctity of their fundamental precepts is better sustained. Mr. Reynolds suggested the legal challenge was broadly indicative of a reluctance on the part of countries in the north of the Eurozone to share the costs of repairing the damage caused by the pandemic to economies in the south, especially Italy. He said, "So there's a massively important moral moment coming up when those in the South are suddenly confronted with the need to evaluate whether the zone is a truly common endeavor or one which is only communal to the extent it is conducted in a way that suits the North, on terms which only work so far as the North regards them as acceptable and within its limited delegation of powers to the EU, rather than terms agreed upon within the EU's voting architecture where Germany and the other states have to live with whatever emerges from the EU's voting arrangements, its court and its other strictures. The German court has determined it remains the arbiter of what it has delegated.